Chapter 21, Agency. What is the law of agency? Agency is really all about the relationship between the client. You'll also see the client referred to in this chapter as the principal. So it is the relationship between the client and the agent. We already know the difference between a client and a customer. So a client is someone who has a contractual agreement with their real estate agent. So if you're a seller and you have hired a real estate agent to sell your house, you have an exclusive seller listing agreement with that agent. That is your contract. That is the employment agreement for the agent. So there is a client-agent relationship. If you are a buyer and you want to be represented fully by your real estate agent, you can have a buyer's brokerage agreement, which is a contract that is signed by the buyer that says, this is my agent. If you do not have a contractual agreement with your agent, you are then considered a customer. So a customer is going to be a person that's working with a broker concerning some type of real estate matter, but they have not signed a contract with that broker. When you look at business in general, there are several different types of agents. It's not necessarily just real estate. You can have agents in other different facets of business. So the first term here is a universal agent. This is someone who has the power to act for the principal in all matters. So an example of this would be a guardian of a minor child, someone who is authorized to sign on behalf of someone else, someone who has power of attorney, for instance. These are examples of universal agents. You can also have a general agent. A general agent has the power to act within limits of a business or an employment relationship. So an example of that would be an insurance agent, an attorney, a property manager. We also have special agents. So special agents have the power to act in a specific event or a specific transaction. So a really good example of this would be a listing agent who is listing a house for their client, and they are going to help them sell that one particular house. It is for one specific transaction. And then after that, it's over, okay? You then have something called a transaction agent. This is where there's no agency relationship at all. So there's no contract that is signed between anyone, but you have, say for instance, a real estate agent who is helping a buyer, but they don't have a contract. So in a situation like that, the agent would be considered a transaction agent. They facilitate the deal, they make sure that everything goes smoothly, but they are not representing anyone. Here we have examples of different types of agents in different areas of business. Here we have different ways that authority can be established in contractual relationships. So first we have actual. This is written contractual agreement. This creates actual authority. We also have implied. This is what is customary in the industry. So with a listing agreement, for instance, it's implied that you can put a for sale sign in the yard of the person's house that you're trying to sell, unless the client says otherwise. We also have ostensible authority. This is the conduct of the parties. So the ways that the parties conduct themselves gives you an idea of who has authority. So say for instance, you have a plumbing leak and you call the plumber and you ask the plumber to come out to your house and fix it. And you tell him, hey, listen, my neighbor is going to have the key to my house. So you can go to the neighbor, get the key, fix my plumbing issue, and then give the key back to my neighbor. You're implying that the neighbor has some type of authority because you're giving them permission to not only pick up the key from there, but also leave it when they leave. We also have ratification. This is where agency is established after the fact. So say, for instance, you have a real estate agent who secures an actual real estate contract without having a listing agreement. So maybe you have an open listing and you bring a contract to a seller or a builder and they accept it, but you actually don't have a listing agreement. This is going to create an agency relationship by law because they have agreed to the contract. And then last, we have estoppel. This is due to principal's failure to maintain due diligence over their agent, and the agent then exercises power over the principal that's really not granted to them. For instance, we do a lot of contracts these days online. I mean, I send it to you, you can sign it with your computer, it's called e-sign, and you send it back to me. There's lots of scenarios where an agent could technically, if they wanted to, they could sign a contract for a seller or for a buyer. If there's a signature that's missing, they could go in and they could fill it in and no one would ever know the difference, right? But that is a problem. So what are the different elements that go along with this agency relationship? If you're entering into an agency relationship with your realtor, then if they sell your house, you have to pay them a commission. Okay? There's also a lot of skills and knowledge that you are going to be able to obtain from that agent throughout the process. Another thing that occurs too in an agency relationship where there is a contract is called a fiduciary relationship. So what is a fiduciary relationship? A fiduciary relationship requires a listing agreement or a buyer's brokerage. So if you're working with a seller, it's a listing agreement. If you're working with a buyer, it's a buyer's brokerage. Now, an agency relationship is considered to be fiduciary when it concerns valuable property or an important transaction. Here's the thing about being a fiduciary agent. If you are a fiduciary agent, you are expected to perform at your highest possible level of competence. And there's several different obligations that you have to your client. So here we have the broker's obligation to their principal or their client. The first one is care, competence, and expertise. You are to represent the principal as if you're representing yourself. We then have obedience. This is faithful performance, lawful instructions. If a client gives you instructions to do a certain thing a certain way, then you're supposed to follow the instructions of your client, obviously unless it's something that they're asking you to do that's illegal or unethical. Accounting. Accounting has to do with accounting for the money. So always keep your client informed of all of the aspects of the transaction that regard funds. And then lastly, we have loyalty. So the principal's interest always comes first. It's not about you as the agent. It's about your client. Never subordinate the best interest of your client. It is always about the best interest of the client. It is not about the best interest of you, the agent. Now, this is very, very difficult for a lot of agents to comprehend because a lot of times that sale, that is your commission. That's how you make your money. That's how you eat, right? So doesn't it have something to do with you? Honestly, if you're in a fiduciary relationship, it does not. You're always supposed to do what is best for your client, not what is best for you. And I've always kind of found that as long as you're doing what is best for your client, what is best for you usually falls in line. So this slide is all about the broker's disclosure liability, making sure that you're fully disclosing everything that you know about the property. So when I say that, I'm referring to material facts. A material fact is going to be a fact about a property that a party doesn't know, couldn't reasonably know, but would want to know. Okay. Also, a material fact is going to be something that would affect the value of the property. So if you have information about the property that would affect value, you're supposed to disclose that no matter what. Okay. Obviously, you cannot disclose facts that you don't know about. So this is one of the obvious reasons why you should always have a home inspection done on a property, because then things that you may not know about, things that you cannot possibly see, can possibly be disclosed in the home inspection. Now, if you do not have a contract with your client or your principal, then you are considered a transaction agent. And there are certain things that you can do that are called ministerial acts. So ministerial acts are acts that do not require judgment and they don't amount to any type of advising or counseling. So they give you a list of different things here that would be considered ministerial acts. Showing property, making factual representations about a property's condition, providing information about comparable sales, pointing out neighborhood amenities, providing information about area schools, utilities, taxes, locating lenders, surveyors, attorneys, home inspectors. You can prepare and you can present offers. So these are what we would consider ministerial acts. If you have a contractual relationship, however, with your client, you can go above and beyond this. That is what that fiduciary relationship allows for. In a fiduciary relationship, you can actually get advice from your agent, counseling from your agent with regards to how much should I offer, how much should I negotiate, what should I take, what should I do. That's the difference between those two relationships. Now keep in mind, no matter whether you're just a transaction agent or whether you actually have a fiduciary relationship with your client, accounting for funds is still critical. So all the funds that you receive from clients or customers are going to go into a trust account that is held by your broker. It is held by your broker until closing. Now there are some companies like the one that I work for where our broker is 4 hours away, and so the real estate attorney that is closing the loan actually holds the funding for us. And there's nothing wrong with that. There's lots of companies that do it. Another thing to mention here with regards to funds is commingling. Commingling is the mixing of a client or a customer's money with an agent's personal money. So you can't take an earnest money check and deposit it into your personal checking account. That is commingling, and that's illegal. There are several different red flags that you need to be aware of whenever you're working with a client or a customer. The first one here is as-is properties. As-is are going to be properties that are sold as is. We're not going to make any modifications. We're not going to make any repairs. What you see is what you get. You can have a lot of problems with that, so be very careful. That is another reason why having a home inspection is super important. So see that very last point down here on this one? As-is house, definitely have a home inspection. Another red flag is puffing. A lot of times agents will exaggerate in their advertising, and so they may make it sound like the house is way better than it actually is. That is an example of puffing. We also have lead-based paint disclosures. If a house was built prior to 1978, you always have to include lead-based paint disclosures. So here we have the buyer's brokerage agreement. The buyer's brokerage agreement is what creates that fiduciary relationship between the buyer and the real estate agent. So now the buyer is way more protected, whereas the seller almost always is protected because they always have a listing agreement. Buyers, on the other hand, usually aren't. So this gives that extra little sense of protection for the buyer. Okay, so there is a lot of stuff going on in this slide, but what I want you guys to really look at is the very first column where it says traditional brokerage. See how you have the seller who is represented by a listing broker. That means they have a listing agreement. And then we have a selling broker who is conducting an arm's length transaction with the buyer. Do you see that? Okay, here's what this means. In this situation, the seller is fully protected. They have a fiduciary relationship with their agent. The buyer does not have a fiduciary relationship with their agent. They have a transaction agent relationship. This is the reason why buyer's brokerage is important. We want buyers to be protected in the same way that sellers are. So look at the second column where it says buyer brokerage. You have a seller who is represented by a listing salesperson, and then at the bottom, see where it's highlighted? You have a buyer who is also represented by a buyer's broker. So each person in the transaction now is represented. That's way more fair, right? Buyers typically are not told about buyer's brokerages because it sort of halts any kind of relationship that you have with your buyer. They just want to buy a house, right? They don't want to sign a contract with you. The only contract that they want to sign is the one to actually buy the property. And so a lot of buyers don't even know that it's around. They're not even aware of it. And a lot of agents don't say anything because they don't want to stifle the relationship that they have with this new buyer that they've just reeled in, right? But you just have to be really careful about knowing everything that's available to you as a buyer and as a seller, but particularly as a buyer, you want to be represented in the same way that a seller would be represented too. Now let's talk a little bit about dual agency. What if I have a house that I have listed for sale, and I've also entered into a buyer's brokerage agreement with this brand new buyer that I've just found? So I have a contract with a seller, I have a contract with a buyer. I take my buyer around, we look at 10 different properties. Which property does the buyer want to buy? The one that is my listing, okay? Now you're probably thinking, well, that's great because you get both sides of the commission split, right? But I have a contract with the seller and I have a contract with the buyer. If I owe both of them a fiduciary responsibility to do the absolute best job for both of them that I possibly can I actually really do that? This is what we call dual agency. When a seller is selling their house, what do they want? They want to sell it for the most money. When a buyer is buying a house, what do they want? They want to get it for the cheapest price. That's typically the way it goes. Can I adequately represent both the seller and the buyer at the same time? That is what dual agency is. Now, if you disclose that you have a situation where dual agency is occurring and both the buyer and the seller say, yeah, well, that's okay with me, then you can actually do it. Most brokerages, however, say, no, we don't think that's a good idea. We would rather do something called designated agency, where the broker will say, okay, buyer, we're going to give you another agent to work with, and Jen's already had the seller for a while, so we're going to let them stick with that. This is one of the major problems with dual agency, is that a lot of people don't realize if the buyer is not adequately represented, the seller is always represented. There are lots of different companies in our area. We have Remax, we have Century 21, we have EXP, we have Berkshire Hathaway, we have Coldwell Banker. Technically, because I am in the same multi-listing service as all of those agents, I technically represent all of those sellers because we're all under the umbrella of Georgia MLS. So unless I have a buyer's brokerage with a buyer is never represented. Now that's really complicated, and I'm not going to ask you guys a ton of questions about this on the exam because I really would prefer to explain this in a classroom setting. But just know, here's your takeaway. If you are a buyer, it would make really good sense for you to be represented by your agent. So sign that buyer's brokerage, and then you're going to be more protected. Remember when we filled out the purchase and sale agreement, and at the bottom of the first page, it was all about agency? And I said, really, all you need to know here is the difference between a client and a customer, that contract, right? That section of the contract is all about disclosure of agency. Agents always have to disclose whether or not they are in a contractual fiduciary relationship with either their seller or their buyer. And so this form that you fill out where you check the box, this is your disclosure of agency. We have just a little bit of disclosure information for a prospective real estate buyer or a tenant. So you can take a look at this on your own. So here we have just a little more information about disclosures. The first one is the owner disclosure information. This is the property disclosure info that a seller is going to fill out whenever they list their property for sale. And it discusses any problems that they've ever had with the property, if they've had insurance claims, what they intend to take with them, what they intend to leave with the house, that kind of stuff. We also have interstate land disclosure statements, and these are disclosures that help to protect people who are buying land in another state without having actually seen the property. And you're thinking, really, do people buy property without having actually seen it? And the answer is, yeah, every once in a while they do. I've actually sold 2 houses before where the customers had never seen the house except with pictures and video. I would never do that, but some people do. Same thing happens with land. We also have antitrust laws. The purpose of federal antitrust laws is to promote competition in an open marketplace. So we're trying to restrict any type of price fixing. So that's the reason I say when someone asks what is the commission to sell a house, there's no set fee. You can negotiate the amount. So it's usually 5%, sometimes it's 6%. It can go higher if it's commercial property, things like that. We then have boycotting. So boycotting is restraining competition, trying to keep other agents from another area out of your specific community. That would be an example of boycotting. And one way that you could do that is by saying, if you're not a member of our individual MLS, then we're going to pay you less commission. You can't do that. We also have errors and omissions insurance. Errors and omissions insurance is purchased by brokers. And so if there's ever anything that is omitted from a contract, the errors and omissions insurance can help you out. If you get fined because of issues that come up with the real estate commission, you're still going to have to pay fees. So the errors and omissions insurance covers some things, but it doesn't cover everything.